7.4, clarification of December 4th, 2012 board meeting minutes. All right, on December 4th, 2012, the sitting board collectively voted aye on agenda item 7.5. The December 4th, 2012 vote was taken in open session by written ballot. The ballots did not contain identifying information of each board member. The vote and result of each ballot was read into the record at the time of the vote by the board secretary. The vote was 5 ayes and 3 nays. The total was recorded per the recommendation of the Public Access Bureau, the PAC of the Illinois Attorney General's Office. Prairie State College has asked each board member who sat and voted on December 4th, 2012 meeting in writing how he or she specifically voted on agenda item 7.5. Prairie State College has received written responses from said board members. The responses were received by and are in the possession of Patricia Trost. I move that Ms. Trost read the written responses into the record and that the written responses be attached to the minutes of this meeting to clarify the minutes of the regular meeting of the board held December 4th, 2012. So I'm looking for a second on that motion.
Second.
Discussion?
Yes. It's unfortunate that we even have to do this. I think that through the gross incompetence of our contracted attorneys that we're
You
here.
do know that one is sitting right here, right?
I do.
And you don't find that that was rude?
Well, but
I apologize for that.
I mean, I think that if it was advised correctly, understanding the Open Meetings Act, that it would never transpired that way.
How can you advise on something that has not been decided?
When you do a secret ballot,
There was no decision prior to this decision of how it should have been voted upon.
well,
So therefore, how could an attorney advise you one way or the other? The attorney can research and do the best guessing to their ability.
adherence to Open Meetings Act as an elected body, that all votes are recorded,
That's not what it said prior to this,
so,
you know.
but they are.
But really, truthfully, it was decided that before this meeting that there was going to be a secret ballot. It was very obvious.
Before this meeting or the
No,
last meeting?
before the December 2012 meeting. It's very obvious that the decision had been made to do a secret ballot. Prior to that meeting, our attorney did have plenty of time to research secret ballot.
But there was no answer there. There's no answer. The Attorney General has never given an opinion up until now. So how
No,
can they
there
say yes or
wasn't,
no?
because the Attorney General placed it on a previous decision that was made on a secret ballot. I mean,
Different
even
set of
I.
It was not on point at all.
Even I, as just somebody who has just taken the Open Meetings Act stuff online, knew that it was wrong. And so, and I agree with Wendell, you know, we even had, I mean, what is the purpose of having an attorney even here at a meeting if we're not gonna get good advice or correct advice? And then we had to pay the attorney for their incompetence, because they made a mistake. We had to pay for it.
That's incorrect, though. They didn't
Oh, we
make a
didn't?
mistake. They did not make a mistake. Did you know what, since you were called, whatever was it, feel free, if you would like to speak up.
I don't need to debate it on or off the record, but I'm happy to provide you with the defense that I drafted on behalf of the college and sent to the AG's office. The law is gray. It went the other way. These things happen. There's law in other jurisdictions to the contrary. There's nothing exactly on point to address this situation.
So in other cases, secret ballots have been upheld, and that's okay?
There is case law in Ohio where that was the case.
Okay.
And
And
it's
now-
cited in the pleadings that we submitted to the AG, who had issued an advisory opinion.
Why don't we go back before the meeting and talk about why we even ever had to get to that?
But that's not the issue.
Oh, but if we never got to that,
it's-
then we would have never had to
No,
have had
we
a
can-
secret ballot or not
It's
secret
not, it's
ballot.
not germane, but yes, look, we can talk about the $80,000 position and why I walked out of the meeting, absolutely. Because it wasn't in the nepotism policy of your
Okay.
stepfather. Yes, we can
The
rehash
secret
all of
ballot
those.
wasn't that though, if you recall. Right,
The secret ballot was not about it, it was our job.
right. But he doesn't want to remember that.
No, but it was to modify, and that was the policy.
Well, he doesn't.
That's what I walked out of.
Right here to say what the secret ballot was about.
Yes.
It's right here in the book.
Yeah.
So, earn some more money.
Anything else? Okay, Madam Secretary. Yeah, I got a second, right?
Yes, I said.
Yes, you did.
Yeah.
Trustee Donahue,
I abstain.
trustee Doyle,
So we're voting on clarifying.
That the written responses be read into the record by Ms. Trost, and that the written responses be attached to the minutes of this meeting to clarify the minutes of the regular meeting of the board held December 4th of 2012.
Can I explain why I abstained?
I wasn't a trustee at the time.
Sure.
Aye.
trustee Bill Corley,
Aye.
trustee Mosby,
Aye.
trustee Wiley,
Aye.
trustee Johnson,
Abstain.
I say aye.
I'm gonna say aye. Ms. Trost?
In answer to the question, how did you vote on agenda item 7.5 at the December 4th, 2012 board meeting? Prairie State College received the following responses from the following trustees respectively. Prairie State College Board Chair Agee, aye. Prairie State College Trustee Doyle, nay. Former Prairie State College Trustee Faso, aye. Prairie State College Trustee Bill Corley, aye. Prairie State College Trustee Mosby, nay. Prairie State College Trustee Summer, aye. Prairie State College Trustee Wiley, aye. And former Prairie State College Student Trustee Shine, nay.
Thank you.